What general principles govern divorce property distribution in Utah? Attorney Kelly Peterson explains. One of the first things that the court will do is try to categorize the property as being either marital property or separate property before engaging in that division analysis. The appellate court case law in Utah is scattered on the subject of property distribution. For example, there is a 1993 case that says there is no fixed formula to determine property division in the divorce proceeding. However, there are other cases that seem to give a sort of formula to it, which will be discussed below. Although the court will begin with the presumption of an equal division of the marital property, the court does have broad discretion and doesn't have to maintain a rigid 50-50 split. Exact mathematical equality is not required. Overall, marital property is typically awarded so that each spouse receives a roughly equal share. The court will begin with the presumption that it should be divided equally, and will usually divide property before conducting its alimony analysis. This is so that the judge can determine if one side has income-producing property or the ability to sell property that may impact whether or not a party will receive alimony. Another principle that the court will follow is that rather than splitting assets in a way that keeps the parties tied together, the court will try to split the assets such that the parties have a clean break from one another. Long-term and deferred sharing of financial assets would likely continue overall hostility and conflict, so the court is going to try to avoid long-term sharing of financial interest. Also, even if one party is considered to be a bad actor, the courts in Utah will not use property division as a way of punishing one side or the other.
Call Attorney Kelly Peterson in Provo, Utah today. The areas of family law are complex and ever-changing. Kelly Peterson has extensive experience and expertise practicing as a family law attorney in a variety of areas.